All right, I salute you for getting here. You had to battle the traffic, and I'm told there's a bunch of crazy stuff out there. It's a crazy world. So today we're going to do drones, one of the key pieces of such a crazy world. I wanted to start and give about 4 or 5 minutes just to sort of, in pedagogical terms, this is called scaffolding. We're going to build the scaffolding and allow y'all, if you're slightly behind, allow you to climb up and catch everybody up so we're starting out on the same level of scaffolding, okay? But I want to spend 4 or 5 minutes just catching up. What questions do y'all have of where we are? Because the way I see us going forward, we're going to do drones today, we'll do human rights and human shields next week, then we'll do a grab bag the following week of cyber war and some other odds and ends things. And the last week, my inclination, unless y'all tell me otherwise, is to focus on the prosecutorial processes and what investigations look like and what tribunals look like, and so I had all the stuff, what this stuff means on the backside when the lawyers get involved and it gets enforced. There's a lot to be said there. But 4 or 5 minutes, what questions do y'all have? Yes, ma'am.
Are you going to talk about Guantanamo sometime?
I will next week a little bit as part of the human rights, human shields debate. The short answer is Guantanamo is much misunderstood and much oversimplified. And shocker, greatly politicized. But you didn't hear it from me. Yes, ma'am. I hadn't planned to touch on Mr. Bergdahl, but I can if you want at some point. We may do that in Grab Bag Week. You know what we could do? We could have y'all email me a whole series of topics, and last class we'll do Grab Bag Week. So I'll put Bergdahl on my list somewhere. All right, what else? Other questions? Yes, ma'am.
The first lecture is on our video, the second one is not.
Well, I'll let them know. It should be at some point. I'm told they all will be. Which is a good thing because I tend to talk too fast and get too excited. So if you're like me, I got slow ears. I'm about 30 seconds behind. Yes, sir.
Well, in anticipation of what China is threatening to do if our Navy sails within 12 miles of their sandbarges.
Oh, good. Yeah, the question is about China and the South China Sea. We're going to touch today on the jus ad bellum piece. We haven't talked much about jus ad bellum, the right of self-defense, yet. I'm going to do some of that today because that's where that comes up. What's the proper line between unlawful aggression and the right of self-defense? We're going to touch on that today. The reason being because that is the determining factor for which body of law applies in the first instance. And that's a really important distinction, particularly when you start talking about human shields. Where does the right of self-defense, to frame it another way, do you extinguish your right of self-defense by being the aggressor? You know, and what does that mean? There's some really dicey, sort of interesting issues there. All right, a couple more questions. 1, 2. And I thought I saw another hand right there. 1, yes, sir.
Were you in Ann Arbor Saturday?
No, I was not. But it was interesting because I was in Ann Arbor on Thursday, and boy, they were all hyped up. This student practically started crying when he was telling me how they're going to beat Missouri. I was like, okay, man. I thought about him Saturday afternoon. I was just like, in case you haven't seen it, it's worth watching the YouTube of the last play of the Michigan State-Michigan game. If you hadn't seen it, it's one for the ages. And I'm sure there's some statistician in there that can tell me the statistical probability of that happening.
Wall Street Journal article, 0.12%.
As they say in my house, never say never. You know. Well, last question. Yes, sir.
Would you touch anywhere on free fire zones?
Absolutely, absolutely. When we do human shields, one of the issues in the human shields debate is the rule of engagement piece of that. So free fire zones are not a law of war issue as much as they're a rule of engagement issue, where a commander simply says, anything in that area that moves, you can presume it to be hostile. Now, if you think that through, sort of as a logical matter, I hope your first gut instinct is to say, wait a minute, I got a problem with that. Why? Anybody? Well, okay, yeah, there might be civilians in there. Never say never, quote unquote. There's no civilians in there. You will never find a civilian in there. True or false? False. So therefore, even if the statistical probability is incredibly low, witness Michigan State, you can just forget about distinction. True or false? False. Remember that basic rule of distinction. You always have the duty under all circumstances at all times to distinguish between enemy combatant, enemy civilian. So you can declare a free fire zone as a political matter, as an operational matter. That does not free the trigger puller of the duty to comply with the principle of distinction. Now, in a real, true free fire zone, where we know, the good example is in the middle of the Iraqi desert in the first Gulf War. No civilians out there, it's functionally a free fire zone. Okay? But to just draw a grid on the map and say you may automatically presume that anything in that circle violates the principle of distinction, which is really important when we start talking about human shields. Right, because human shields, by definition, what somebody is doing is combining innocent, otherwise lawfully protected civilians with persons, in the language of the law, taking direct part in hostilities. It's that commingling that causes problems. Okay, and you know, so the concept of free fire zones has been around a long time. It's very controversial. It's also theoretically possible under the right circumstances, but remember, it's got to be that commander responsible for applying the laws and customs of war that really carefully does that. One of the other key issues then would be, so commander does that in rules of engagement, does that absolve everybody below that commander? It's a huge debate. Technically, no, it doesn't. But they feel absolved, right? Because they say, hey, I'm just doing what I was told to do. How's that going to work at your court-martial? You know, it doesn't work. So it's a real it's a real problem in practicality, particularly, and I'll tell you the biggest problem is in urban warfare. Remember, when you've got the duty to warn, when circumstances permit, you've done all of these warnings. We've spent 6 months warning the Germans that this place is going to be bombed. So I'm tired of doing all that warning, and now I declare that everybody who's left there is automatically a combatant or automatically a target. Good idea, bad idea? See, you still have that residual principle of distinction insofar as possible. So, all right, one last question. I said that was the last, but I stretched the truth just for you.
What are the legalities in helping to overthrow a sitting leader?
Oh, we can talk about that one. That's a good grab bag week question. The jus ad bellum commingling the self-defense stuff of a sitting head of state. That's a fun question. Y'all are so smart. Y'all are so smart. All right, let's do some targeting and drone law. Some of this is review, and some of this is stuff that I didn't get a chance to do last meeting. Yes, ma'am. I don't know. You want me to lay on it and hold it down? So this is kind of where we're going conceptually. I'm a picture guy. So here's your picture for where we're headed, which is that we're always talking about these distinctions between rights and duties. See, it is the same length, a sufficient length. We can carry them out on our shoulders when we're done. Here's where we're going, and I think you're kind of doing this intuitively, but you always need to be thinking the two sides of an issue. The rights accruing to a particular situation, both legally, morally, politically, etc. What are my rights versus what are my duties? And it really does come down to, this is oversimplified, mind you, it doesn't give you all the complexity of that, but typically your rights come from the right of self-defense, South China Sea, for example. Always, and on an individual level, the right to exercise individual, personal self-defense. Nobody can ever tell you, you cannot return fire. You must sacrifice your life for whatever purpose. Wrong. Violation of my fundamental right to life. Now that's in law of war terms. In human rights terms, we've got this special field called the law of derogations. And we're going to touch on the law of derogations next week. The idea of derogation says that you've got your range of human rights, okay, but in some limited legal contexts, that range of human rights are restricted. Good example, World War II, we've got gas rationing. I've got the right to travel. I can get as much gas as I want to drive to California anytime I want to. No, you can't, right? Because you're human right. The right, the freedom of assembly in the middle of an armed conflict. Those kinds of things, okay? But the law of derogations is affirmative what gives the government the right, the governmental prerogative, if you will, to incur your human rights, to limit them, under specified circumstances. On the flip side, of course, all the range of duties, right? So in human rights law, we talk about use Kogan's norms, the rights, the basic rights that everybody in the world recognizes, even when they violate them. They create an excuse why, or purported legal rationale, okay? So the big one is the right, not the use Kogan's norm that says you can never aggress your neighbor, you can't invade your neighbor unless you've got a lawful justification, right? The right not to be tortured, basic human right, use Kogan's norms. Applicable in all situations at all times. The only question is which piece of law carries the import, carries the weight, the load-bearing pillar, if we got any construction engineers here, right? That's the only question, but that right, I guarantee you, will be there somewhere. Okay? Those are use Kogan's norms. And then the big one is the law of human rights we're going to do next week, and then the law of armed conflict. The key issue there, and that's why I've got these touching each other conceptually, which box are we in? Okay? And the reason it matters is because the rights that accrue to a particular commander or a particular foot soldier are going to vary, differing, in the human rights box or the law of armed conflict box. As we will see today, a little teaser for you, the most pointed difference is in the law of proportionality. We're going to see that here in just a minute. Okay? So that's kind of where we're going the next couple of weeks. All right, this is what this looks like. We're going to do jus in bello again a little bit. I want to focus on jus ad bellum, and then we'll get into drones. And I want to pick up something I meant to do last week. We just didn't have time because I talked too much last week. I think everybody gets this at this point. Again, this is an oversimplified picture, but it's powerfully impressionistic in the sense that it does give you a sense of how complicated this is in terms of the choice of law. Lots of law out there. And the only question is, which set of legal principles do I prioritize, and for what reason, under what circumstances? Okay? But it's important that, again, that concept of use Kogan's norms and fundamental human rights, you see, it's the pillar, it's the foundation of all this stuff. Okay? In other words, the core human rights, or if something in the rarefied air is a core use Kogan's norm, it's going to apply all times, all places, all circumstances. And the only question is, which piece of law is the load-bearing pillar that really implements that particular right? Okay? And there's a lot of law there. We can come back in that week and grab bag week if you want. One thing I wanted to clarify is sometimes you'll see in the law this line between armed conflict between states and armed conflict not of an international character. You'll hear all kinds of phrases out there. I mean, you've all heard the war on terror phrase kicked around the last decade. There is a school of thought, and the most vocal example of that is the Israeli Supreme Court. In a particular case, the targeted killings case, which is relevant, of course, to our drone discussion, the Israeli Supreme Court basically took the position that I bet every one of you, if you were a sitting judge, would not have taken, because you learned some of this stuff now. When do you have an armed conflict in the international sense? Anybody? The phrase is armed conflict. This would be a good fill-in-the-blank question. Armed conflict between two or more states, two or more high conflict. Exactly. That's the language of the law. That's the language of the Geneva Conventions. It's a pretty simple, straight, cut and dried rule on its face. Then the subordinate question is, when does a non-state actor or a non-state group have sufficient state backing that we're talking about the functional equivalent of a conflict between two states? Okay? But it's still a conflict between two states. It's just that one state has an agency relationship with the non-state actor group or the terrorist group or whatever they are, sufficient to make that legally a conflict between two or more states. Everybody see that? Here's the question. Yes, sir?
Would you add in something about belligerent status?
Absolutely. Y'all know for a fact, when do you have combatant status in a non-international armed conflict? Real true combatant status in a non-international armed conflict. Anybody? Nope. Never. Remember, because true combatant status reserved for that particular class, and the reason, go back to my slide of rights and duties. Remember, combatant status, real legally granted combatant status, is going to give you all that range of rights that accrue to lawful combatants. The right to kill, the right to bomb, all that range of rights. On the flip side, because you've got that range of rights, what's the impact of the law of war? All it's going to do is to constrain those rights. Meaning, when I'm a real combatant in the lawful sense and I have complied with the law of war, principle, distinction, proportionality, etc., what's the net result? What do we do with combatants that kill lots of people? We give them silver stars, right? Because they've complied with the law. Okay? Here's the key, and this is related to the principle of belligerency. In the early beginnings of this era, we recognized this problem. At what level does a non-state group or a non-state armed conflict that we would normally say is not between two states, at what level does that rise to the functional equivalent of an armed conflict between two states? The classic law going back to the 1860s in the Lieber Code recognized this principle of belligerency. And the idea was the American Civil War is the paradigmatic example, okay? Or the American Revolution, a paradigmatic example. You know, early on, the first thing Parliament did when they signed the Declaration of Independence, this may strike a little close to home for some of y'all, they said, Parliament passed a bill that said everybody that just signed that Declaration of Independence is a traitor and therefore what? An unlawful belligerent. They're all war criminals. Why? Because those punks have no lawful right to wage war against the king. In the same way that Al-Qaeda, Al-Shabaab, Hamas, Hezbollah, all of them have no lawful right because they're not a state. So they're non-state, sub-state groups. So the law of belligerency developed after that to say there's a line, it's an imprecise line, but there is a line at which that non-state group assumes enough of the state-like aspects that we will now presume that to be a belligerency for the purposes of armed conflict. American Civil War is the classic example. You control territory, you got a functional government. Both the Union forces and the Confederate forces said law of war fully applies, not just as a matter of policy. This is the key. It's not just as a matter of policy at that point, or pragmatics, or expediency. At that point, when you got a real full-blown belligerency, it becomes a legally binding mandate. Okay? The problem with that is it's still a mushy line. So here's the key I want you to understand. The law of belligerency at this point is sort of an outdated relic because what we've done through the years is we've updated the Geneva Conventions. Okay? We've, for example, swept in the French partisans into the 1949 Geneva Conventions. So now the point is, as opposed to just broad customary international practice and accepted principles, today there's some black letter law on when you get that status. You've got to go to the 49 Geneva Conventions if you're a partisan, etc. Okay? So today there's black letter law on this, and here's the key. The Israeli Supreme Court said in the targeted killings case that anytime you've got a conflict with a non-state actor group that transcends borders, so they make up this label, a transnational armed conflict. What do you say, Judge? Judge, jury, what do you say? It's in the language of the Israeli Supreme Court. Get this right. They say, we're going to presume that for this particular purpose, the Israeli military may use targeted killings against individual terrorists, and the full body of law of armed conflict applies as a matter of law, not a matter of policy or expediency. So you see what they're saying. They're saying this is an armed conflict between two or more states, except it's not an armed conflict between two or more states. It's a transnational sub-state actor. That's what they did. They just imputed the fact that the conflict, because of the terrorist organization, crosses borders, you see, that the full body of the full panoply of legal rights and duties attaches to that terrorist group. What's the problem with that? Well, two big problems. Anybody? Number one, I'm sorry, they're not a state, period. Walks like a duck, quacks like a duck, wants to be a duck. And why do they want to be a state? To be clear. I mean, why is Hamas delighted, or Al-Shabaab, if somebody says, well, Al-Shabaab has operations across the border, Therefore, automatically it qualifies as a full international armed conflict because there's a transnational dimension to it. Why is Al-Shabaab just simply delighted with that? They want silver stars. They want combatant status. They want the lawful blanket. Remember, first class, I talked about Harry Potter's invisibility cloak, right? You've seen that, I'm sure. If you haven't, it's probably worth doing to stay culturally relevant. I had my kids drag me to it. When you have combatant immunity, you're essentially wrapped in that blanket of the law, the protection of the laws and customs of war. So long as you comply with the laws and customs of war, you are not a criminal. That's why they want this. So that's what they did in this case. And my point to you is that's the one aberration. It's an exceptional case, and there's dicta in there, which is non-binding language. There's dicta where the Supreme Court says, we're not making a principle for all of international law for the whole wide world. We're just making a principle for Israeli armed forces to comply with our human rights obligations. I get all that, but they're still wrong on that basic legal principle. They are dead wrong. Okay? And that case is the aberration. So, anytime you hear somebody saying Al-Qaeda has transnational operations, or ISIS operates transnationally, people flow, of course, money flows, etc. ISIS is now engaged in international commerce. If we went back to the old law of belligerency, we would apply some indicia, some sort of sliding scale. Well, let's see. They got a government, sort of. They control some territory, sort of. They're engaged in transnational commerce. Yes, they are. You know, they're now granting visas and rights of free passage and all that, so they're beginning to have some immigration and customs stuff. You know, at some level we would say, well, wait a minute. They're getting close to state-like aspects that rise to the level of belligerency. Wrong. If you did that, you'd be buying into what the Supreme Court of Israel said. They're just wrong on the law on that. So my point to you is you've got to go back to the basic principles. It's a set of legal principles defined in juxtaposition to each other. If it's an armed conflict, follow the logic, if it's an armed conflict, the only question is it an armed conflict between two or more states? If it's not, then what is it? It's an armed conflict not of an international character, okay? It's like a solar eclipse, right? Everything else falls in that very broad category. And the really important point about that, I want you to get this, is that in that other zone, any terrorist activity, Al-Shabaab, Hamas, ISIS, etc., we're in that armed conflict not of an international character zone where we're talking about a pretty complex blend of human rights law and rights of self-defense and basic treaty law applicable to the law of peace and pieces of the laws of war. Whereas once we move into the international armed conflict zone, law of war provides me pretty much one-stop shopping. Now, I like that as a lawyer. It makes it real simple. Woo-hoo! I don't have to look for the law. It's right there. But in the world we live in today, that's why this stuff is hard, because we're in these non-armed conflict, not of an international character against these sub-state groups, in a world where the classic law of belligerency is not recognized anymore to the same extent. So that's what makes it hard. Which next week when we do human shields and human rights, we're going to get into that neck deep. All right, 3 questions. 1, 2, 3.
I was going to ask about.
Oh, I'm sorry. 4, 3 and a half.
I was going to ask about ISIS, but you already answered that.
Good.
So, what did the Israeli government gain by changing that law? Alternatively, if they didn't have the change in the law, how would it be made to change?
What the Israeli government gained was the ability to say, as a technical matter, the law of target, which I would have said anyway as a matter of customary international law, that the provisions on targeting apply to the Israeli military as a matter of treaty law, not discretionary practice or customary international law. That's all they gained. Functionally, nothing. Not a thing.
And so therefore, we gain nothing.
Except to say we're applying the protocol of this body of law as a matter of black letter treaty law. We're applying it because we recognize it to be legally binding in its own right as against us, as opposed to just reaching out to other sources. Number 2. You were number 3, man, but he's going to be kind and chivalrous and let you go first.
Before you discuss the Israeli Supreme Court decision, I wanted to know how you would discuss the Kurds, the Ukraine,
great example. In the classic law of belligerency, we would make a pretty strong argument that the Kurds had risen to the classic level of belligerence. Therefore, when they went into Syria, they had full combatant status. Not true. Not true. It's complicated, but not true. We'll do the Kurds. If you want to do ISIS and the Kurds, I've been in Kurdistan. I've been in there with them. I've been at Mount Sinjar. We can talk about that in Grab Bag Week. That'll be a lot of fun. I'll show you all pictures. Lots of pictures. I'm sorry? Same thing. Same thing. Good Grab Bag Week topics. Yes, sir. Good Grab Bag Week. Good Grab Bag Week topic. Let's do targeting. Let's do targeting. All right. We already went over the basic principle. Now, because of the Israeli Supreme Court, and this is a good example, we would apply this as a matter of custom, right, and as a matter of pragmatism and as a matter of policy, not as a matter of binding, black letter, directly applicable treaty law. After the Israeli Supreme Court decision, they apply this to the Palestinians in Gaza or the West Bank as a matter of black letter treaty law. And this is the basic definition, as this is review. Now, we talked about this. We talked about it for some of y'all too much. Quit talking, say the people. But there's your basic, and the key question then is, when does a person offer a definite military advantage? Okay? And if I did a multiple choice test, I would just say, as a pretty easy toss-away multiple choice question, when does the intentional killing of a civilian offer a definite military advantage? Anybody? Well, I didn't mean that to be a trick question. When does the intentional killing of a protected civilian, let me say it that way, offer a definite military advantage? Anybody? Well, but see, that's not... Here what we're talking about is the law when I can intentionally target and directly attack that person. So by definition, somebody that meets this objective, I can intentionally target them, and I'm not worried about peripheral issues. I'm always intentionally attacking a lawful target. So Mary's point is, I think, spot on. Her instincts are good. Right? You see, when a civilian is, in fact, a real high-value target that offers a direct military advantage, I may intentionally target them. So in a non-international armed conflict, I've got that sort of quasi-middle ground. They're still a civilian, right? They're still a civilian. Why? Because it's a non-international armed conflict, and a civilian who's doing a lot of things to participate in the conflict and goes in front of a judge like Kawaja in the Canadian Supreme Court and says, I'm a combatant, combatant immunity, what would you say? If you're in Paris, you'd say, no. Right? No such thing as combatant immunity in the non-international armed conflict. So that's where this becomes very important. The death of that particular person does offer a definite, distinct, articulable military advantage. But the shift here is that we're not targeting them based on status, based on the fact that they're lawfully a combatant. Now we're targeting them. We could do that in the international armed conflict, of course. But now, in the armed conflict, not an international character, Mary's exactly right. We would target them based on what they are doing. It's about conduct. It's about contributions, if you like alliteration. Okay? It's about conduct. It's about contributions. It's not about combatant status. Okay? So therefore, let me give you the legal phrase. The legal phrase is civilian directly participating in hostilities. Okay? That's what the Israeli Supreme Court was grappling with. No problem. See, Saddam Hussein is easy because it's an international armed conflict. It's an armed conflict between two or more high contracting parties. That's easy because we're on the other side of that line. Okay? This is a good example. Osama bin Laden, there's a lot of Europeans that say, wait a minute, Osama bin Laden not directly participating in hostilities at the time he is targeted intentionally. Therefore, I've debated European lawyers. What do the European lawyers call that, many of them? Murder. Why? Because the full range of human rights law applies. When can the cop intentionally kill somebody under the law of human rights? Only under very narrow exceptions, which we did not meet in targeting Osama bin Laden. From the American perspective, exactly the opposite. Does targeting Osama bin Laden offer a definite, definitive, concrete military advantage. You bet your bippy it does. Right? But we're applying the laws and customs of war. So Osama bin Laden, is he a combatant at the time the SEALs enter? Good, we're getting somewhere. Everybody shake your head vigorously. He's not a combatant, but what is he? Civilian directly participating in hostilities. And so in that middle ground, you see, here's what's interesting. You're still a civilian. Why are you a civilian? It's a very simple binary logic. You're a civilian because you're not a combatant. Okay? So you're still a civilian, but you're a civilian directly participating in hostilities. Ergo, ipso facto, you become a lawful target. Everybody see that? Now, all that does is give you the ability to target somebody. Then we're going to enter into all the other stuff we've been talking about. The duty to warn is yes, no. The duty to take all feasible measures, yes, no. The duty to proportionality, to minimize or eliminate collateral damage, yes, no. The choice of tactics, choice of timing, all these other collateral questions. But all this does is get you the very first a priori right to target somebody. Okay? And you see this, the variation of this, you see it with property as well. Same exact analysis, right? Does killing the tank offer a definite military advantage? Sure it does. This is Kosovo. So technically, you can still lawfully target said tanks or said equipment or whatever, but then we're going to go through the other rubric of legal analysis and say yes, no, proportionality, distinction, blah, 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 blah. Everybody see that? Now these questions become critically important when we get to drones. I wanted to show you a targeting process. Now this is, oh yeah. Gotta love the lawyers, don't you? I didn't make this up. I wish I could. I couldn't, I'm not creative enough to make that up. This is the NATO targeting process. Okay, so this is the I will tell you, this is the unclassified version of the NATO targeting process. The classified one has some more lines on there. Now, the key point is, this is a deliberate target. This is a target where we've said, this is how you plan, for example, the Osama bin Laden operation. You ask about Osama. It's deliberate targeting. Okay? Now, this is the targeting process from Kosovo, so that's why you see that. Is this still working? Yeah, you're good. This is from Kosovo, so that's why you see the EUCOM bullet there. And where below at the very bottom where it says forward to the NAC, North Atlantic Council. That's why the French have veto power over every airstrike that goes in. So if you were paying attention and you see the headlines, you know, U.S. bombs the Chinese embassy. You know, it's a plot. You know, and the undercurrent there is, well, the U.S. just decided to bomb the Chinese embassy. Guess what? The North Atlantic Council, every one of them, to include the French and the Brits and the Germans and the Italians, approved that strike. And what they're reviewing when they do that is the two levels, compliance with the laws of armed conflict and the overarching political imperative. Okay? Now this is the NATO targeting process in its unclassified form, very similar to what we're doing in Afghanistan today, but remember, these are deliberate targets. Okay? These are the ones where you have time to plan, and a good commander is not going to just, you know, you walk in, the lawyer walks in, and the targeter walks in and with a swagger and says, hey boss, we got this figured out. Does the good commander just say, okay, no problem, I trust you. Yeah, just don't screw it up. No, that good commander pulls that thing and teases it apart, and the good commander pings them with questions. You're telling me this? How do you know that? Right? Because my name's on the line. It's my authority that we're implementing here. That's where you see the repeated involvement of the European EUCOM commander. Notice how many times EUCOM pops up on there. See, implicitly that's saying that a commander exercises oversight over every ounce of that process. And when it isn't right, it's the commander that says, go back and do it again. Okay? Everybody see that? Now this ought to stand in contrast for you to, this is a planned operation, this is a deliberate strike, a drone strike. A U.S., as we sit here today, if we were planning a drone strike, it's going to be that exact same process. I would change the verbs, change the nouns in there, okay, and the participating agencies, but it's exactly the same process, okay? That's when we have time to plan, of course. Obvious contrast to times when we don't have time to plan. So this is basically the way And now it's gotten unbelievably sophisticated. Back in my day, I felt like I was using a slide rule back in troglodyte era. But you know, today, the computer modeling of this stuff is unbelievable. It's just phenomenal. So the shorthand version, you'll say to a commander, this is a Tier 4 target, or a Tier 1 target, or a Tier 2 target. The computer modeling of collateral damage is unbelievably important and unbelievably precise, based on the intelligence assessments, based on what we know. But still, the good commander doesn't just defer to the computer, right? The good commander and the good lawyer is piercingly penetrating that. But this is how you do the proportionality analysis, right? You know, you've satisfied distinction, you've satisfied the feasible measures, you've satisfied the duty to warn if it's there. Now you're looking at the core proportionality analysis. How much likely damage is anticipated vis-a-vis, remember we talked about the military advantage anticipated. And how are we going to calibrate those? What's the relationship between those? But the other point about this is it's always iterative. Okay? It's always iterative because information is always changing. The circumstances are always changing. The people are always changing. You think the terrorist just sits there and says, "Hi, I'm here. This is my headquarters. Please plan a deliberate strike and I'll make it easy for you. I'll move away from the mosque. You know? I'll move away from the civilian apartment building." Right? I could show you if you wanted and if I had time, and if you want me to, I'll show you the slide of a particular example where you're doing this analysis in Kosovo of what is an actual lawful military target. It's a military police station that's being used as a headquarters for the non-state armed group. No problem with the legality of the target. The picture I took was from ground level, looking up at a woman, a Bosnian woman, hanging out her laundry in the morning. And it's a good, I'll bring it in next week and show it to you. It'll be a good way to review next week. The point is, if you attack that thing on an east-west axis, you got civilian low-level single-family homes on one side, you've got the lawful target, then you've got this about 5-6-story tall apartment building on the other side. If you attack it on an east-west axis, you're really endangering everybody in that field of strike. So fine, you shift it, you attack it at a north-south axis, right? Because behind the place is a parking lot, in front of it is a road, and that's exactly what happens. One bomb hits the road, the second bomb destroys the target, the third bomb goes in the parking lot. Serbian lady loses some sleep, she doesn't like it, she gets woken up. And the press says, U.S. disturbs the peace of innocent civilians, right? As opposed to killing them. That's a good example of complying with the principles and spirit of this stuff and doing it right. And I'll show you the big hole that a 500-pound bomb makes. Okay? She's better off getting, and then she gets up the next morning and she's grumpy because she didn't get sleep, hangs out her laundry. Okay? That's what this process is about. It's about refining that, saying, not good enough, go back and redo it, recalculate. You got to satisfy me, the commander, before I authorize that. Okay? 2 questions, quickly.
How long does your flowchart take? How many hands is involved in working through that?
Short answer, a whole bunch. I've seen it done in as short as like 6 hours. It can be done very, very quickly. The norm sometimes is 2 to 3 weeks, depending on the target, depending on the. It's all context specific, but it's, and it raises a really interesting point. What do you say to the commander that says, the heck with it, bag it, it's just too hard? I say you have the right to remain silent. Anything you say can be used against you in a court of law. You know. I say, sir, go to your jail cell while I interview everybody else. Right? Because you can't do that. All right? Quickly. Yes, sir. Yeah, that was Kosovo. Oh, right. Yeah.
What is the process when you're targeting an individual?
Exactly the same.
Women driving in a Hilux, down the road, and, the guy's loitering,
Yeah.
you won't loiter.
Great question, because it illustrates. His question is, for those who didn't hear it, what do you do when you're looking at a convoy? Muhammad Omar is escaping from, Afghanistan. Mullah Omar. Classic case. That is the deliberate targeting process. What you're talking about is a hasty target. It's a time-sensitive target. I don't have time to go to the North Atlantic Council for political approval what I want you to understand is the process is functionally the same. Why? Because the law is the same. It's just being done at a decentralized, much lower level and much more rapidly. And there's where we make mistakes. We make big mistakes. I mean, my personal pet peeve, can I get on my soapbox for a second? Y'all mind if I soapbox for just 2 seconds? Okay, my 2 seconds are over. No. So in the Gulf War, we go into Iraq. You go through this entire incredibly complex analysis. Muqtada Sadr has an arrest warrant issued by an Iraqi judge for crimes of murder. Absolute rock-solid murder case. Iraqi judge under Iraqi law issues a warrant of arrest for Muqtada Sadr. Okay, now, Muqtada Sadr at that point also, by the way, just to review, what is he? He's not a combatant because we've got an armed conflict, not an international character. We've got an insurgency, but what is he? He's a lawful target, but why? He's civilian directly participating in hostilities. So some U.S. commander, and I know who it was, no names, says, I could order a deliberate strike to kill or injure this person. Why? Because I have the lawful right. He's a lawful target. He's killing Americans all over Iraq. Or I could order an arrest operation pursuant to this lawful arrest warrant. Because remember, you're in that zone where human rights law fully applies, crim law fully applies, and pieces of the law will apply. We have got the roadblock in place. The convoy is, this is your convoy question. The convoy's driving down the road. Special forces seal behind the convoy. You've got SEALs you're watching with a drone. You've got the entire routes of avenue escape. And all you've got to do is to, I started to say pull the trigger. You could pull the trigger literally. But metaphorically, you've got to decide, I'm committed to this. It's the right thing to do. We're going to do it. And that gutless American commander called it off. And after that, how many thousands of Americans died and suffered, not to mention Iraqis, because Muqtada Sadr was still walking around. The point is, when you go through this process, you've got to be careful, you've got to do it right, but you've also got to have confidence in the decision that you make. And we chickened out. We got gutless there. Well, not we, one person, one commander got gutless. And the point is, does that factor into the proportionality analysis? No, not technically, no, because all that is hindsight. Remember, the proportionality analysis, those zones of damage, are what I reasonably anticipate at that time based on the information available to me. That's why it's hard, because the stakes here are very, very high. We've got to get it right. Okay, and the way we brief this stuff is with these target packages. This is just a real stripped-down target package. We'll walk in and in one, we don't convene the North Atlantic Council to convene and come together and talk about one target. Right? When you go through that political process, or in our context, in the American, a deputies meeting, the Deputy Secretary of State, the Deputy Secretary, the deputies, or the principals even, a cabinet meeting, we don't do one target. We do a package, a briefing. And this is what it looks like. You do a targeting folder for each and every one. So in the end, you're getting something like this. And then you're having concrete discussion about that particular thing and the nuances, both law and policy. And at that point, you go no-go. Or somebody says, wait a minute, change it, tweak it. Attack at a different time of day, different weapon, different. And then the clincher to all of this says, don't attack it from the air at all. I mean, go back to Osama bin Laden. You were curious about Osama. Could we have just leveled said, here's that I started to say conclave, compound, thank you. Here's that compound. Okay? Everything within that compound gets reduced to rubble. Could we have done that? Maybe, but it would have been a really controversial thing to do because you're on somebody else's soil. And more importantly, the proportionality analysis is completely guesswork because we don't know who's there. We don't even really know for sure that it's Osama bin Laden. That's why, remember, the background option for all this stuff is don't do any of that. Send in somebody on the ground. See? And there, it's the same set of legal principles, distinction, proportionality, duty to warn, all that stuff, but it's a different actor doing the acting. All right? Everybody with me? Good. Let me dispense of one thing very quickly. A couple of follow-up questions, and then I want to dispense with this, and then we'll do drones. We're doing great on time. So a couple of short questions. Yes, sir.
At what,
I like George. George has always got something to say.
at what command level are we talking about that this happens? If you're in a tactical situation, you don't have time to go to the Joint Chiefs.
You're making an assumption. No, you don't have time to go to the Joint Chiefs of Staff, but you still have the same range, full range of legal duties and obligations. They just look different. You know, the Marine in Fallujah is going to go through that analysis in the split second to say, and he won't use, by the way, the Marine in Fallujah will never, and I don't want him to use the legal terminology. I'm going to give them a very straightforward set of rules of engagement and say, go out and do this stuff, son or daughter. I'm just going to, because I don't want them debate, well, wait a minute, what is the concrete and direct, what is the distinct military advantage, what is blah, blah, blah. I don't want them doing that. That's my job. I do want them, though, to have the training and the self-discipline to say, I don't know the answer, but I'm encountering this, or my unit is encountering this a lot. Let me get an expert in here. That's what I want of them. Because you've got to make these decisions snap fast, but you still got to do it right. Okay? Yes, ma'am. And then we'll do targeting.
As you told the government commander, were there any consequences for the execution?
Nope. Except that a whole bunch of Iraqis and Americans died that didn't need to. That's my soapbox. And just the simple point is, these things all have consequences, for good or ill. Okay? Now, very quickly, let's dispose of this. And there's a lot of law here, but it's not relevant to us, really, except the basic principle. A lot of people will look at game theory, and they'll say, well, it's kind of unfair. Like poor Osama bin Laden, poor guy. Don't you feel bad for him? Right? With the whole weight of the U.S. government hunting him down, and CIA agents out there, and agents of other intelligence services out there, and the entire U.S. Air Force. How would you feel if the entire U.S. Air Force was focused on hurting you? You wouldn't puff your chest and say, bring it on, people. No problem. Right? And so some people look at this, particularly human rights advocates, look at this and say, well, wait a minute, that's not fair. Because you're singling out an individual for all of this massive amounts of lethal force, okay? And therefore they try to impute into the law through the back door of human rights law. Remember, under human rights law, when can the state intentionally target and kill a private civilian? Never. Unless, of course, and if you're in some country where capital sentencing is allowed, that's fine. There's an exception in human rights law. Or, obviously, the cop that interrupts, you know, an armed confrontation. When you're shooting at a cop, you better expect to get shot back at. Or you got an incompetent cop, right? Because you have absolute lawful right to use self-defense. So there's your two exceptions. Absent that, human rights law says, nope, you never intentionally target civilians. And so people extrapolate from that human rights principle into the laws of war. Now, what would the law of war look like if the legal rule was, you may never intentionally target an individual person? It's like dumb, isn't it? I mean, I hate to say the law is dumb as a law professor, but the law would be really dumb. That's why it's not the rule. But I promise you, I was in an audience, I was on a debate panel one time with a very, very distinguished human rights lawyer. I mean, world-renowned name, great guy, great professional. And he made the statement, and I was like, let me hear that. I know I have tanker's ears. I told you, I've got armor ears, tanker's ears. I have slow ears. I have southern ears. They operate at about 45 seconds delay. He made the statement, in wars of the future, killing will be illegal. And I said, no, I didn't hear that right. And then he said it again, in wars of the future, killing will be illegal. I said, unless we fundamentally abolish this body of law. Because the whole point of this body of law is that killing is lawful when you do it correctly. It's a permissive body of law. Remember, we get back next week, we're going to do permissive, restricted. So the point is, anytime you hear somebody saying it's a violation of the law to intentionally target a specific person, look at them and say, what? Ah, good. Woo, smart lady. It depends on whether you have complied with the principle of distinction, for example, on whether you have issued a duty to warn when the duty to warn applies. But the basic baseline rule, of course you can target an individual, provided you do so lawfully. Okay? Now that's the heart of the drone debate, by the way. You'll see lots and lots of stuff out there if you start reading drones. I just wanted to show you this quickly. I don't have time to do all this detail, and it's really not relevant for you, except to say, and if you're interested, I'll send you a whole I got about a dog pile of readings on this. The concept of direct participation in hostilities is bitterly debated among lawyers in the world. There's a whole bunch of push and pull here. There's some people that want to make it incredibly broad. Anybody seen the critique of drone strikes, for example? I'm not making this up. People say, well, if you're a widow in Switzerland who donates to Hamas, then you become a lawful target. That's out there. Well, then that's stupid, right? No. There are some people that want to stretch that concept of directly participation past its breaking point, okay? There are other people, including the International Committee of the Red Cross, that wants to make it incredibly confining and restrictive. Now, why does it matter? I'll tell you why it matters, and you know why it matters. Because on one side of that line, you're a fully protected civilian who may never be intentionally targeted absent imminent self-defense. I mean, real right up close self-defense. Okay? On the other side of that line, you may be lawfully targeted, provided you do it in accordance with all the lines of the rule. That's why that legal rule matters. Civilian directly participating in hostilities. A bunch of law out there, and we can talk about what that means. For some reason, this thing quit working. So let me get it back where you're going. Now, another piece of this debate is the fact that, unlike the Israelis, the United States does not apply Protocol 1 as a matter of law. We hadn't signed the treaty. We recognize it as broader, customary international law. And I thought it's useful just to take a second, and then we'll do drones, to tell you why. The big reason why, going back to the Reagan administration, is this clause, Article 44.3. 44.3 says that follow the logic, a lawful combatant who is a combatant, there are some circumstances where that lawful combatant need not carry his arms openly or participate. All that lawful combatant has to do in order to preserve combatancy is, when visible to the adversary in a military deployment immediately preceding, carry arms openly. So follow the logic. If a person was a combatant under that rule, I could have my bomb hidden on a civilian airplane, and as long as I whipped out my little Al-Qaeda hat and announced as I set the bomb off, hey, I've got a bomb, immediately preceding, then I would retain my combatant status. You see the problem with that? And President Reagan said, we will not ratify that treaty because, in the U.S. opinion, that gives too much protection to terrorists. Okay? Now, all of our friends and allies around the world are not stupid. They saw the same issue, and what they did was they ratified the treaty. Every NATO state ratified the same treaty with that same clause in it, but then they did reservations and declarations to chip away at the legal meaning of that. So in the end, we and the Brits are in the same place on this. The functional difference, though, this is important, they have all those legal principles as a matter of binding law because they ratified the treaty. We don't. Okay? This is important because when we start talking about a drone strike with France or England or the Brits or anybody else, we're looking at the same rule, same legal language. They're looking at it as a treaty duty, a treaty obligation. We're looking at it through the lens of state practice, through the lens of what's advisory, what's expedient, what's let's say policy. Very different lens. Okay? Now that we got all that baseline, I'm not going to be political here. We're just going to read this and make it up. Now, I'm not going to read it to you. Y'all can all read. Take a second, though, and analyze for me what he's talking about. So, targeting policies, including lethal policies with UAVs, that's politically correct ways for drones. Okay, so all these drones we got scooting around out there, we're going to comply with all applicable law, including the laws of war. First question, what's he talking about? What's all applicable law mean? Yes, sir? Yeah, human rights law. That's exactly what we're saying. As a matter of policy, the unstated and invisible ink, of course, is when it applies, to whom it applies, how it applies, based on our determination. But yeah, what he's saying is we're not going to just ignore human rights law. What else are we just not going to ignore? Well, we said the law of war. That's right. We're not going to ignore the law of war. We're going to comply with that. We're also not going to ignore this vast subterranean complex of U.S. regulatory law. The lines of legal authority, for example, between the CIA and the Department of Defense. A lot of law there. We're not just going to throw that out because now we're talking about drones or we're talking about terrorists overseas. And the other technical piece is we're still not going to ignore host nation obligations. We may very well have, and we do in parts of the world, particular agreements or particular treaties, again, that shape legal rights and norms. So all that stuff remains fully applicable. But under that umbrella, we're going to carefully review the rules governing targeting operations to consider their, and that's that targeting process. That's that NATO. So trust us, we're the government. We're doing all that stuff. And what are we doing when we do all that stuff? We're complying with this distinction. We're complying with proportionality. And then they correctly state the rule. But they correctly state the protocol rule, not the modern. This is technically, it's an incorrect statement of proportionality. Okay? And if you've read my book, you know why. And then lastly, trust us, we're the government. Great care is taken to adhere to these principles, both in planning and execution, to ensure both pieces. We're only attacking lawful targets, and when we do attack them, we're only doing, in the conduct of that, what is lawful. Trust us, we're the government. I'm sorry? This was Harold Koh's policy statement to ASIL. Oh, shoot, I should know this. 2013, I want to say. It's recent. I mean, this is not the Paleolithic era, folks. I want to say 2013. Might have been 2014. I have to go back. 13, I think. Okay? Nope. Yeah. The same statement you would get today for ISIS or Hamas or Hezbollah or anybody, Al-Shabaab. Okay? I'm sorry? Because in that particular context, Harold Koh was the stuckee to stand up. Now this, by the way, is interagency cleared language. This is not Harold Koh standing up and speaking in his individual capacity. This is Harold Koh standing up with an interagency cleared document. The CIA clears on it, National Security Staff clears on it, DOD clears on it, and State Department clears on it, because he's the person at the forefront of getting the questions, why are you doing this? What is your legal authority? There was a period of time, you may remember, where the administration was just very guarded and very closed. Don't ask us why, we have legal authority. Plenary legal authority. They began to get pushback on that, particularly from human rights advocates, who said, wait a minute, you're around the world targeting individual people and killing them. You bear the burden of proof of showing an affirmative justification for that. So there was a campaign to correct that. So Brennan made a statement, the National Security Advisor made a statement, Koh made this statement, and some others. Let me give you the follow-on to that. And this is very straightforward. Some have suggested that the very use of targeting to target a particular person violates. True or false? False. But then we go back to the old concept of belligerency. Notice it. We say, therefore, because you're a belligerent, you're a lawful target under international law. Now critique that. I know we got some English instructors in here. What's your critique as trained, informed, scholarly experts? What would you say? Think back. If you're a real belligerent under the classic law of belligerency, then what are you? A combatant. And when do I target? Why? I'm going to say it another way. When I target a combatant, what's the legal basis on which I target that combatant? Simply it's based on their status. It's simply based on the fact that they're a combatant. That's what he seems to be saying. The problem is, are we in an armed conflict of an international law to which we can say that any Al-Qaeda actor is a combatant, ergo a belligerent? No. So the English teacher would say, word choice. Word choice matters here. The correct term is civilian directly participating in hostilities, or lawful target within the meaning of Article 48. You know, you could rattle off the law. Lots of other ways to say it, but you don't just shorthand that incorrectly by referring back to belligerency. That's the problem. All right, now go on. The second paragraph. Some have challenged the advanced technologies unmanned against individuals. What do we say to that? It's just another tool. It's a vehicle. It's not a sporting match. Right? Who's a Mets fan? You know, remember when you were kids? Did y'all ever play outdoors when you were kids? I have to ask that because the new generation of students, they're like, ooh, outside, there are germs out there. I'm like, you know, get outside, go eat dirt, you know, it'll make you healthy. But you remember when you were a kid, I was a baseball player, and when we were little kids, you kind of had a slaughter rule. Right? When you get 15 runs ahead, 15-0, time to call it off, slaughter rule. Right? Now that's sport, that's fairness, that's chivalry, that's all, and I agree with that when you're 6-year-olds playing kickball. In an armed conflict, it's exactly the other way around. I want to do everything I'm lawfully permitted to do as often as I'm lawfully permitted to do it. Why? Because it is not a sporting match. We're not talking about fairness. In essence, yeah. I mean, it's a modified, but the point is that that's a key dimension. It's an implicit aspect of legality, right? But this idea, which he alludes to, the problem I have with the speech is, though, man, put it to bed. Like slam it. Don't just kind of glide past it rhetorically. Slam dunk that thing. Make it clear to the world that we will do everything we are lawfully permitted to do, so long as we are lawfully permitted to do it, so long as you're directly participating in hostilities. So you people out there, Hamas, Hezbollah, whatever you want to, you know, ISIS, whatever group you want, what's your favorite terrorist group? You know, what's your favorite group of the day? The group du jour. Guess what, folks? You get the choice. Right? Do you want to be a civilian? Do you want to live your life and not be targeted? Great. Do what? Go do it. Exactly. Go do it. It's your choice. But make no mistake, the minute that you pick up arms and decide to directly participate against the United States of America, you are now a civilian, say it with me, a civilian directly participating in hostilities. Ergo, we're coming at you. Your choice, your call, but we've got every lawful right in the world to do it, provided that we do it lawfully. That's the point. And he just kind of glides past that. And then the big one is, and I referenced this, it is true that in U.S. law there's a long-standing executive order that prohibits assassination. So a lot of people, again, you try to conflate the law. You try to say, well, anytime you kill an individual, that's a prohibited assassination within the meaning of the executive order. Okay? And the problem is, you're conflating bodies of law. Right? If I go target a political leader in a time of peace, what do we call that? That's murder, that's an assassination. Why? Because human rights law applies. In a time of armed conflict, I've risen above that threshold. Now I'm in a situation where the law of armed conflict applies, which means that human rights law, not that it ever goes away, but the choice of law, the first principle is law of armed conflict, which means I decide to target an individual. What's the relevant question? Is it that I'm targeting an individual or not? What's the relevant question when I decide to target an individual? Say again? Are they directly participating in hostilities? If you are, game over, I'm above that threshold. Then the legal question is this whole ancillary set of questions. Now, yes, sir? Yeah, no, it's a good question.
Who makes that decision?
It's a set of legal standards. In the law today, particularly in international law, we talk about this concept of fragmentation. Anybody ever break a vase? I broke a vase one time and thought I was clever, and I reassembled it and glued it and all that, and it never looked the same afterwards. And boy, she caught me too. I didn't get away with it. That's the law of fragmentation. The point being that in modern international law, there's an abundance. The legal word would be plethora, if you allow me to use the law professor word. Most would say an overabundance of authoritative mechanisms that try to declare that. So I could show you case law from the International Court of Justice. I could show you case law from the Yugoslavia Tribunal. I could show you case law from a whole bunch of German cases. The Germans in Afghanistan were accused of a war crime. And the defense said, hey, it wasn't an armed conflict, ergo, full domestic German law applies. Murder, not a lawful killing. Lots and lots and lots of places. There's a core of agreement. And it basically says two things. Number one, the line, again, we're talking about the line between human rights and peace and law of armed conflict. Two basic principles. One is that true law of war application in armed conflict, and the language is, it's not random, it's worded in the negative. It's not random, it's not sporadic, it's not isolated. See? The Oklahoma City bombing. Are we in an armed conflict because the Oklahoma City bombing happens? Nah. Terrorist act. True terrorist act, purely governed by domestic law. It's sporadic, it's random, it's unpredictable, it's not taking place under an organized, cohesive chain of command, etc., etc., etc. Okay, so that's the first piece. The second piece says that there have to be organized armed groups. There has to be a level of organization in arms. So you could argue, if let's say you live on the southwest Texas border and you got Mexican gangs coming across, wait a minute, we've risen to the level where it's sustained, it's violent, it's no longer just normal criminality or gang activity. There's an armed conflict mode here. That's the question you get. It's how organized is it? How sustained is it? What's the level of violence involved? Is it a particular kind of thing where we need military force to respond or police force? But it's a mushy test. But I will tell you, in practice, almost nobody disagrees. In the end, this is a question between the United States and allies. We are in an armed conflict. And I don't know of a situation where everybody disagrees. Ukraine. You know you're in an armed conflict in Ukraine. The only character is what's the nature of the conflict. And I could give you lots of other examples. Quick, because I want to do this slide. Yes, yes, sir.
I'm assuming that when they took out our line, they didn't as
Yep, no question.
What about Imam in London?
We'll come back and do that when we do Grab Bag Week, because I want to do this. Let's read this carefully. Now I want you all to tell me what body of law they're applying. This is your exit exam. Okay? Get this right and we'll all go home. Or go back to sit in traffic. The President has authority to respond to an imminent threat posed by Al-Qaeda. What body of law is he referring to? Review from a few weeks in the Latin term, but what's he talking about? The law of self-defense, jus ad bellum. The problem is, if I'm just basing it on jus ad bellum, the law of self-defense, the proportionality principle is derived from that body of law. Much more constrained, much more limited. Okay? Keep reading. And he has a constitutional duty to protect the country. The inherent right of the United States, now he says it clearly, to national self-defense. So we're talking about national self-defense. Fine. He also has congressional authorization to use all necessary and appropriate force. Problem with that is, what's that? It's just domestic law. So that gives you, great, but it's not necessary because we're talking about international norms here. Lastly, we do have an armed conflict against Al-Qaeda that's defined under international law. You see what we're doing? It's Halloween. We're going to call this grab bag. You know, what we're doing is we're throwing a bunch of law on the wall, and you can pick and choose whatever you want to believe, but don't pin me down. Don't make me pick. You pick, and just whatever makes you happy is fine. Let's keep reading, folks. This is the strike against al-Awlaki. The condition that an operational leader presents an imminent threat of violent attack does not require the United States to have clear evidence that a specific attack on persons or interests is going to take place in the immediate future. Now, what's he trying to do there? What's he doing? Now, remember, you've got this tension, this fault line between these two bodies of law. In fact, if we're going under the law of self-defense, when can you use the law of self-defense? When it's really imminent. Imminent means what? I hate to sound like Bill Clinton. What does imminent mean? Imminent means imminent. Right? So if I'm under the law of self-defense, I bear the burden of proof. It's imminent. It's necessary. The law of proportionality says I'm only going to use that degree of force necessary to eliminate the threat. It's really imminent. But oh, by the way, it's not really imminent. Because implicitly, what other body of law is he referring to when he says, well, imminent really kind of means what we want it to mean, broader out there. Why? Because what's he referring to? It's not, he's straddling that line. If something is not an imminent threat, but we still articulate the ability to go lawfully target it, what are we relying on? Ergo, he is what? A civilian directly participating in hostilities. Wait a minute, that's not self-defense law anymore. What's that? Law of war. But we've mushed them together into one sentence. And now it gets really fun. Al-Awlaki. That's why I sent you the Al-Awlaki article. Al-Awlaki in Yemen. The United States can use lethal force against even a U.S. person located outside the United States who's an operational leader continually planning attacks. That language of continuous planning comes from the International Committee of the Red Cross Direct Participation Guidelines. The problem is, as a technical matter, nobody agrees on that as the definitive statement of the law. Fine, we choose to borrow it, that's fine, but let's call it what it is. We're adopting a policy limitation, a policy filter. Okay? So you're continually planning attacks. Now notice, right there, we've made a distinction between a non-U.S. person and a U.S. person. We've said the non-U.S. person doesn't have to be imminent, doesn't have to be continuous, as long as we think we got it. U.S. person, continuous, imminent, engaged. Now follow. But we've got to satisfy the following things. The targeted person poses an imminent threat. Okay? That sounds like what? That's self-defense. So you got self-defense. The capture is infeasible. We hadn't talked about this. We're going to talk about this next week. When would you sort of hypothesize that you have a duty to capture, an affirmative obligation to try to capture somebody before you take the decision to launch a drone strike? Anybody? Here's your PhD level application answer. Not a civilian directly participating in hostilities, so when do I have the cop on the street? Does the cop on the street have a duty to try to capture a criminal? Why? Human rights law. We would call it civil rights. That's human rights law. So we got, no, this is a drone. This is the legal decision to target Al-Awlaki. Yeah, oh yeah, that's right. So on the first hand, we've got imminent threat, self-defense. Second thing, we got human rights law applying, saying capture is infeasible. Drum roll, please. Are we going to get cleared up in the last sentence? What do you think? We're going to tie it in a nice, neat little bow and make it all simple and easy? Of course not. We're going to make it more complicated, where such an operation could be conducted consistent with applicable law of war principles. So in the same sentence, in the same legal justification, and I promise you, this is the United States drone policy right here. I'm not making this up. In the same sentence, we got self-defense, which is one set of legal principles and rules. We got human rights law, which is a separate, distinct set of legal rights and principles and duties. And we got law of armed conflict, which is a third set of legal principles and duties. Okay? That's why when you hear people criticizing the drone policy, that's why you hear it. You get a human rights advocate that says, wait a minute, you haven't fully complied with human rights, and human rights is in fact a strand of your policy. Because you're not picking, you're not just relying on self-defense. Let's say self-defense. And I agree, by the way, if we relied solely on the law of self-defense, it would have an absolutely catastrophic constraining effect on the law. It would basically mean that you could only use lethal force when you catch the terrorist in the process of setting off the bomb. Or, Osama bin Laden. If that's the rule, is Osama bin Laden an imminent threat? Continually participating? No. Ergo, it really would have been murder. And that's a nice place to stop, because next week, we're going to pin our ears back and dive into some human rights law. Okay? Particularly with the context of human shields. See y'all next time, if you choose to come back.